Totally agree. And now a super chat, which is going to bring us into the next subject. In the case of Michael Flynn, what's the chance that Sullivan is removed from the case if the whole bench rehearing is allowed? So everybody knows the Michael Flynn situation. Sullivan filed a petition for rehearing en banc. It seems that it might have been outside of the delays, but maybe they're not counting non-juridical days. I don't know how the delays work, but it was filed on the 9th. And it's basically nothing more than a regurgitation of Gleason's arguments in his amicus, of Wilkins' arguments in the dissent, basically just saying all of the arguments rehashed. The Court of Appeal got it wrong. It's a serious enough issue. We need the full Court of Appeals to hear it. One of the main questions, well, one question that I had, and I think I know the answer, but let me know, had the Court of Appeal reassigned the judge, he would have still had the same remedy to make a petition for rehearing en banc to undo the decision that reassigned him from the case?
Yes. So the as to the specifics of the question, yes, the en banc court could either remand the proceedings and not grant the writ, or grant the writ and change it to require his removal. Both of those I think are unlikely. Now, I thought the majority of the DC circuit was GOP appointed, but it turns out I was mistaken. Majority is Democratic appointed. So that is probably why he has filed the petition for en banc review, is that they're politically aligned with him. The court did stay the case, which is unusual. Normally they don't stay the issuance of the mandate automatically, but they did do so here while they consider opposition. And I will still be surprised if they take it. I think it's problematic if they take it, but they may. If they reverse, I think it will probably go up to the U.S. Supreme Court, because somebody on the judicial side of the aisle has to make it clear that judges are not prosecutors, and not to open up this can of worms, this Pandora's box. So, for example, I mean, a lot of people are saying, hey, he wasn't given a chance to rule and so forth. The real problem here was he was creating a special prosecutor's office through his amicus rulings and his suggestions of threats of criminal prosecution for contempt. So it wasn't just his delay in ordering the dismissal. If all he had done was not dismiss it yet, he would be in much better position. But he went much further than that. He said, basically, I want a special. We're not
losing Barnes.
Oh, can you hear me?
There's a bit of a lag. I'm just going to see if everyone is. Let's see.
Okay.
Yeah. Okay. I think we're good. Yeah. So sorry. Keep going.
No problem. It was probably, immediately we started talking about Flynn, the CIA is starting to get involved. It's extraordinary. The whole case is extraordinary. I mean, it and the Roger Stone case are two cases about how criminal prosecution should not occur in the United States. And they're extraordinary in what they're educating. But I was surprised he filed it, just because it makes him look contained. Put it this way. The reason why he was not removed by the panel was because of their hope that, can you still hear me?
Yeah, but it's bouncing in and out, but I don't know if it's mine or yours, but we'll do this as long as we can.
Okay. The people say they can hear, the person with Chinese symbols say they can hear me.
Okay, good.
So we're good. So I can hear myself. So that always works as a lawyer, right? So I think as a component of it, I was surprised he filed it, because he really made it clear that he should have been removed, because he's not willing to get the message. But
it's crazy.
Completely.
The thing that drives me nuts, two things, and I said it in the video, but I'll say it again. He is accusing the Court of Appeal of expanding the scope of the mandamus or mandamus. Yeah. Now, I never did a mandamus in law, but I know that they're not like diamonds in the ground. They're used often enough as recourse. So it's not like that is being expanded in any unseen way. But that's exactly what he was trying to do with the the leave of court in granting a 48A. So he's accusing the Court of Appeal of doing the exact same thing he's doing. And the other thing that just drives me nuts is his consistent oversimplification, mischaracterization of what he was doing. I just wanted to consider both sides. I just wanted a hearing. You didn't need to hire an amicus, let alone that amicus. If all you wanted was a hearing, you could have the hearing, and I presume it's the same thing in the States. Judges can ask all the questions they want. They can be more proactive or more passive during a hearing. he did not need to appoint an amicus. He didn't need to schedule the hearing. He didn't need to add questions to the debate. I mean, in theory, he could have raised contempt on his own, I presume. He didn't need to suggest to a hand-picked amicus who's already shown animosity towards Trump and the process to do this. It's just crazy.
Completely. He chose a special prosecutor is what he de facto did. So he may not label it that, but that's what he did, to have the power of subpoenas, to have the power of discovery, to have the powers to leak to the press, to have powers to make statements he himself doesn't want to make on the record, but wants to have made on the record. And this has never been done before that I know of. And I haven't seen them cite a single example of this ever occurring. So clearly, if it had happened, they would have vouched for it with evidence. So I find it deeply problematic. It's unfortunate that General Flynn has to go through all of this to finally get vindicated. He should have been vindicated by July 4th. Instead, they bought a little extra time by how they interpreted the rules. So it got to be the day or so after the 4th that they filed the last possible minute they could file. They filed their petition. I hope the D.C. Circuit understands the environment they're in, that this is ill-advised, that they should just not touch it. But you never know. There are a lot of Democratic judges on that panel. So we'll see.
Actually, Aaron E. says, what does it say that Sullivan had to ask for en banc himself versus some of the other Dem-appointed judges doing it? Seems he waited to see and no one did it. Maybe that's why it took until the last minute?
I assume that, well, technically there still could have been another day or two for the other judge to do so. So I guess he interpreted the fact that it wasn't done right away by the dissenting judge. The dissenting judge could ask for an en banc review. So just that dissenting judge could cause all this process to occur. It struck me as he was really motivated by I mean, what I said back when we first did this is that he's a very arrogant man and that he's dumb as a bale of bricks. And I stick to both of those statements. I don't have confidence in his competence, and I don't have confidence in his ability to recognize that how he's being perceived. I mean, now for the first time, a Republican member of Congress is suggesting bringing impeachment against him in the House. Now, it won't go anywhere as long as it's a Democratic House, but as a federal judge, you don't want anybody talking about impeaching you. So somewhere along the way, he should wake up, but he's clearly in his own world completely.
And that is, a lot of people were asking what the remedy is. Can he be removed from the bench? Basically, the only way to remove a federal judge is through impeachment.
Effectively, courts can kind of do it. They have some supervisory powers to quote unquote suspend a judge. It's constitutionally questionable what the scope and scale of that power is. I've had well, I guess you could call it fortune to be in front of some judges who've been suspended for attitudinal issues. And got the privilege of being in front of them afterwards. Let's just say they had not necessarily been cured, but it can happen. But generally speaking, the only clear constitutional remedy is impeachment.
Okay, and now I'm gonna read Vicky Rose's.
I should say I'm not in favor of his impeachment. I have the same standards as I did for President Trump. Yeah, it needs to be a crime. Now the standard is lower for a judge. It's in good behavior, lower than it is for the president. But I'm not in favor of impeaching judges unless they've committed criminal conduct outside of their duties as a judge.
Yeah, and I can see that with this. I mean, I think it's egregious. People suspect corruption. People have all sorts of theories of, deep state and all sorts of other more sinister, but more unprovable suspicions. Bottom line, he might just be a stubborn judge who thinks he's right and he wants someone to tell him he's right. I think that's exactly who he is. I don't think he's corrupt. I just think he's very stubborn and he lives in his own world. And I think his clerks have badly served him here. Judges like Sullivan tend to depend heavily on their clerks. The clerks are overwhelmingly in that little lefty social media world. They have no clue. They're the kind of people who think defund the police is a popular political position to have. The theory of corruption that I might have is why he filed the petition for rehearing. Yeah. Well, if he loses, at least the lawyers who are being paid by taxpayer dollars get to do their work and put 4 lawyers on this, put out a 20-page document. If it wins, it wins, and if it loses, they get paid. And Sullivan doesn't care. It's just
that's why I'm not in favor of this process. I think he should have done it all himself. Have his clerks write it. Shouldn't have been any private counsel involved. Should have been within the scope of his duties. He's more than capable of doing so with his clerks, and that's what should have happened. I don't like this private prosecutor process at all.
And so the next steps now, the delays that I wasn't aware of when I made the video, but the delays now, who gave Flynn and the DOJ 10 days to respond? Was that the
D.C. Circuit? But that can be done by a single judge's request. So even if just the dissenting judge in the panel decision requested it, then that would be granted. And the same with the stay. They granted the stay pending that occurring. So
Explain what the stay means. The stay means that they're not going to force the issuance of the mandamus while this goes on. It makes sense because they couldn't get the result and then have it potentially be undone if his rehearing is granted?
That's correct.
Okay. So then 10 more days from the 9th, if it's juridical days. It includes weekends unless it falls on a weekend, then it goes to the next legal day, juridical day.
Yeah, we're probably talking about end of July, early August before this is wrapped up. Okay. And you never know. He may go up to the U.S. Supreme Court and request to stay the whole thing for the U.S. Supreme Court, which would push it to October potentially. So again, I do think the political objective here, I don't think this is Sullivan's objective, but I think the political objective of maybe some of his clerks is to force Trump to pardon Flynn. But I think, but the reality there is Trump can wait until after the election, because even if he loses, he's in office until January 17th. And if people look at the history of pardons and commutations, most of them happen during the dead period after an election before an inauguration.
All right. If anybody's got any more questions about Flynn, we know what we're waiting for now. We're going to wait for the responses. They are going to schedule a hearing date, or is it going to be?
Did I rewrite that? I think Sidney Powell's already responded. I know she filed something in court. It may have been the discovery, but I think she was ready to go right away.
Okay, well, so, we'll be covering that if and when something else comes out. But so they have 10 days to respond. They're going to respond. Is there going to be oral arguments, or is it just going to be written and the judges are going?
Normally they just deny the petition. They almost never, like in the States, it's interesting. And I think your pronunciation is the technically correct one, but in the States we call it en banc. We actually pronunciate the C.
It's a French term.
Maybe it was originally I think it's all because all these terms were originally Latin terms, and like if I recall right, French, Spanish, and Italian are all derived in some capacity from Latin. And some of our old legal terms were Latin in origin, but only if they say yes. It's very rare to have an en banc oral argument. That almost never happens, even if they decide to grant the en banc petition. But generally speaking, they almost never grant en banc petitions. So I would be surprised if they grant en banc petition. But again, it is a Democratic majority on that circuit. So I would no longer be shocked if they do so.
Okay.